1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်321ဦးစိန်တောင်း and another applicants vs the Union of Burma and two others respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Revision before ဦးကျော်ဆန်းဦး and ဦးချစ် judges ဦးစိန်တောင်း and another applicants vs the Union of Burma and two others respondents Code of Criminal Procedure Section 145 A proceeding is pending until finally concluded, whether misjoinder or non-joinder of parties do not affect jurisdiction. Hell, a proceeding must be considered pending until it is finally concluded. Therefore, the application in revision must be taken to be a continuation of the original application. Questions of misjoinder or non-joinder of parties do not ordinarily affect jurisdiction. An order under Section 145 of the Code of Criminal Procedure is not bad merely because all interested persons are not implicated. The order is valid so far as the parties in dispute are before the court. It will be in the best interest of the parties concerned to implicate the applicant number 1 and the 2 other children of the deceased, namely Makinji and Mamiminte, as well as the eldest child of the couple, namely Matla Myin, as legal representative of the deceased. Induguri, Savanara Jana Raju and others vs. Induguri vs. Wanaharaju and others AIR 1942 Met page 249 Ms. Rancho Das Jetabai Company vs. the Humble Minister for Judicial Affairs and others 1952 BLR page 227 SC 233 refer to Ulajo for the applicants Umyoton Lin government advocate for the respondent number 1 So Tai Long Chanton Ang and Kim Maung Nyo for the respondent number 2 Ujo San U Judge. This is an application to set aside or modify the order and finding date 18 August 1966 of the 7 additional magistrate of Rangoon passed under Section 145 of the Code of Criminal Procedure in Criminal Miscellaneous number 86 of 1966, declaring that the respondent number 2 company is in possession of the Nyayatana Cinema Hall, which is the subject matter of dispute, and entitled to retain possession of it. The Court of Session Rangoon, in its Criminal Revision number 33 of 1966, recommended to this court to set aside the order of the magistrate, giving its reason in its order date 3rd January 1967. After the conclusion of the argument of the counsel for the applicant, and in the course of hearing of the counsel for the respondent number 2 company, adjournment was granted as the parties desire to talk about settlement out of court. In the meantime, the second applicant, the wife of the first applicant, died and counsel for the respondent number 2 company raised a question as to the necessity or rather, the propriety of implementing the legal representative of the deceased as applicants in the case, the applicant number 1 and his wife being Burmese Buddhist, the applicant number 1 as the widower of the deceased offer himself to be implemented as a former applicant as well in place of the deceased as legal representative, but the respondent number 2 company contends that the applicant number 1 and the deceased being THAUNG, the latter brought 2 daughters by her previous marriage and produced 6 children by the applicant number 1, 4 of whom are minors, and accordingly, the other children should also be added as legal representative of the deceased, stating that adding legal representative in the case is not a mere formal matter. The applicant number 1 insists that it is sufficient if he alone is added as legal representative of his wife. A legal representative is a person who in law represents the estate of a deceased person or upon whom the estate devolves on the death and includes any person who intermeddles with the said estate. It is needless to say that under the Burmese Buddhist law, the estate devolves on the applicant number 1 on the death of his wife in the absence of an Orasa child, who, if there is one, share jointly with the applicant number 1. It does not transpire from the record or from the arguments of the counsel whether the first child of the couple, namely Malami, is an Orasa child. Under the Burmese Buddhist law, where there is an issue of a previous marriage of the deceased, such issue may succeed to the deceased estate together with the step-parent. It is therefore clear that the first applicant and Malami, who apparently is an Orasa, and also the 2 daughters of the deceased by her previous marriage are the legal representative of the deceased. In fact, there is no dispute about it. Under subsection 7 of section 145 of the Code of Criminal Procedure, which was substituted in 1923, when a party dies, the magistrate has the discretion to cause the legal representative of the deceased to be made a party, and if any question arises as to who the legal representative is, all persons claiming to be representative of the deceased shall be made parties thereto. The counsel for the applicant number 1 contends that this subsection applies only to proceeding before the magistrate and not to this application in revision before this court. The purpose of the provisions in this subsection is to keep alive the jurisdiction of the court where the danger of peace still exists in spite of the death of a party to the proceeding. Before the amendment, the death of the applicant, even in revision in the High Court, caused the application to abate, but not so now. In Induguri, Sayanarayana Raju and others first, Induguri, Viswanath Haraju and others 1, it was held that where after filing the revision petition against an order under section 145(7) before the High Court, the petitioner dies, the High Court, in view of the provisions of section 561(a) and 435, has ample power to bring the legal representative of the deceased on record if the ends of justice require it, after all proceedings in revision are really continuations of the original proceeding. Ms. Rancho Das Jetabai and Company Fest, the humble Minister for Judicial Affairs and others, 2. A proceeding must be considered pending until it is finally concluded. Therefore, this application in revision must be taken to be a continuation of the original application. There is, as pointed out above, no dispute as to who are the legal representatives of the deceased, but the point to be considered is whether all the legal representatives for the purpose of this application should be impleted or not. Questions of misjoinder or non-joinder of parties do not ordinarily affect jurisdiction. An order under Section 145 of the Code of Criminal Procedure is not but merely because all interested persons are not impleted. The order is valid so far as the parties in dispute are before the court. In the instant case, we are of the opinion that it will be in the best interest of the parties concerned to implement the applicant number 1 and the 2 adult children of the deceased, namely Makinji and Mamimyente, as well as the eldest child of the couple, namely Matlamye, as legal representative of the deceased, and accordingly we direct that they be implemented forthwith as applicants in the case. The hearing shall now proceed.